welcome to Crime and Court. This is the Menendez brothers case, California versus Eric and Lyle Menendez, and we're going to read through the Amicus Curiae brief, which I believe that's how you say it. Um, heard others pronounce it that way. As with a lot of these Latin words, there's probably multiple pronunciations, but I'm going to go with what I heard. All right, so um, again, I'm still, recovering from surgery, but I wanted to get an episode to you on this case. And so I'm just going to do voiceover only just to get us by because it's hard for me to look like a human when I'm recovering from surgery. All right, so this is, plus I gotta like lay back and get comfy because my hips, I can't sit up for too long. So, um, but not to talk too much about my health. I'm doing good. I feel good. My healing's going well. So, moving on. So let's get to this amicus curiae. This is so. What is it? What is an amicus brief? Basically, it is someone. So you've got your parties in a case, which is basically your plaintiff and your defendant, or the state versus your defendant, rather in this case, and so those are the actual parties of the case, which would be the state of California and Eric and Lyle. They're parties to this case. So another party, an outside party, can intervene when there's a case, especially when it's in superior courts. They can file this amicus brief saying, here's some information that maybe you don't have, but it provides context to your case. And, these attorneys can just, freely enter these briefs as they see fit, whenever there's a case that is, worthy of doing so. So, Eric and Lyle had nothing to do with this. This is, the American Psychological Association and the California Psychological Association put together this brief to ask for a leave to file a brief. Oh, they're just um, asking to file this brief. So here is, so we're going to read through this. This is a long one, so we're probably going to do this in two parts just because, especially me sitting so long, I'm going to have to break it up probably. But here we go. Application of the APA and the CPA for leave to file a brief amicus curiae in support of petitioners. So you can already tell, you can see that they are in support of the brothers. So they have their habeas petition out there. So then this, came along. People saw that brief and decided we're going to intervene and give the judge some information that they don't have. All right, so the American Psychological Association and its affiliate, the California Psychological Association, seek leave to file the accompanying brief amicus curiae in support of the petitioner's interest of amici curiae. I don't know if I'm saying that right, but let's go with it. So, the American Psychological Association has been the principal professional association of psychologists in the United States since 1892. A long time. Its membership numbers more than 100,000 nationwide. You would think for being that large, they would have more members, or being around for so long, they would have more members. The California, I mean, not that that's not a lot. That is a lot of members, but anyways. So the California Psychological Association, the CPA, is a state affiliate of APA and has a membership of more than 5,000 licensed psychologists in California. APA and CPA members in clinical practice treat hundreds of thousands of patients each year who are willing to enter treatment only because they expect and rely on confidentially of their patient therapist relationship. APA and CPA members therefore have a substantial interest in legal rules that preserve the patient's right to confidentiality, the right that is at issue in this appeal. So, confidentiality, legal rules that preserve the patient's right to that confidentiality. Um, Sorry, hold on one second. Sorry. Okay, let's move on. So, the scope of confidentiality and evidentiary privilege also is important in defining psychologists' professional obligations to their patients. Like APA and CPA members have a concrete interest in judicial decisions that may require termination of their therapeutic relationship with some patients. By holding in this case, that the therapeutic relationship terminates automatically by operation of law prior to the time when patients and therapists actually decide to discontinue treatment. The Court of Appeal stripped patients of significant rights, divested therapists of their duties, and dictated an end to therapy. APA and CPA members have a vital interest in ensuring that if such termination is legally mandated, it be done under appropriate rules. The APA and CPA are familiar with the questions involved in this case. They believe there is a need for additional argument on the following points, which APA and CPA address in their proposed brief Amicus Curiae, which is submitted with this application. Summary of points to be argued. The Court of Appeal made two important rulings in this case. So this is um, prior to their habeas. Once all of their appeals were exhausted. This is what they're talking about. Their appeals process that has been since exhausted, and they've been basically since 2005 they've known that they're serving life without parole because they've lost all their opportunities now to appeal. So this, going back to the document, it says the Court of Appeal made two important rulings in this case. One, that therapy by definition always terminates whenever a patient threatens to harm his or her therapist, and therefore, two, that whenever a patient threatens to harm the therapist, all subsequent communications with the therapist lose their confidentiality. If this court affirms these rulings, the chilling effect on potentially dangerous patients and their therapists will be so strong that few, if any, such patients will continue treatment following their voicing a threat. And that makes sense. Therapists basically saying, like, if we allow this, then you're going to cause a chilling effect in future individuals. It's going to make them not want to confide in their therapists or return to their therapists. Therapists will be professionally obligated to inform these patients that confidentiality has ceased, and most such patients will leave. Therapy that could avoid future violence will not be provided, and future warnings will not be given. By abruptly aborting therapy to these dangerous patients, such a rule would result in more, not less, danger to patients, therapists, and the public. Equally important, public awareness of this rule would deter from even entering treatment large numbers of people who are not sure what they may say in therapy or how the legal rules may be applied. Yeah, it might make people afraid to even seek out a therapist because if you're if what you're talking about with your therapist at some point in time can become not confidential, why would you want to go and risk that? If suddenly the courts are starting to say, well, no, uh, these confidential conversations are now going to be made public. Finally, the Court of Appeal standard substitutes for the relatively clear rules under existing decisions a vague rule that requires a court to reconstruct and divine the primary intentions of mental ill people and their therapists. In People versus Wharton, this court struck a delicate balance between the compelling state interest in protecting citizens from harm and the constitutional, statutory, and common law rights of privacy in the patient therapist relationship. The Wharton decision held that only the content of actual warnings to third parties and the statements that triggered those warnings are non privileged under the dangerous patient exception to the patient's psychotherapist privilege. So only those threats or those warnings would be not confidential, would be considered not ruled as a privileged information. In Wharton, two justices dissented, believing that even this waiver of confidentiality went too far and construed the dangerous patient exception too broadly, but at least the Wharton rule embodied some balance. Common sense standard confidentiality is breached only to the extent necessary to protect the public. Now, however, the real party in interest seeks to sweep aside the Wharton rule in favor of a total disregard for confidentiality any time that a patient credibly voices a threat. Because of the large number of patients who threaten their therapist or another person at some time, this new proposed rule would end all confidentiality and perhaps therapy itself in large numbers of cases. You see the snowball effect? If you rule one way, then it's going to have this effect going forward on all cases. So be very particular before you make your ruling. Think it through. This court should reject the invitation to so radically move beyond Wharton to discard confidentiality and to create a rule that will increase rather than decrease the public's exposure to dangerous people. The APA and CPA request that the proposed brief Amicus Curiae accompanying this application be received and filed. So that was just the letter to the judge or the judge's, who's court clerk staff. All right, let's get to the page here. All right, so, all right, interest of Amici Curiae. The American Psychological Association, or the APA, has been the principal professional association of psychologists in the United States since 1892. Its membership numbers more than 100,000 nationwide. The California Psychological Association, or the CPA, is a state affiliate of APA and has a membership of more than 5,000. Okay, we read all this. Blah, blah, blah. APA and CPA members in clinical practice treat hundreds of thousands of patients each year who are willing to enter treatment only because they expect and rely on confidentiality of the patient therapist relationship, sorry. APA and CPA members therefore have a substantial interest in legal rules that preserve the patient's right to confidentiality, the right that is at issue in this appeal. The scope of confidentiality and evidentiary privilege also is important in defining psychologists' professional obligations to their patients. So it's important to understand the scope of confidentiality. Likewise, APA and CPA members have a concrete interest in judicial decisions that may require termination of their therapeutic relationship with some patients. By holding in this case, this is all repeated. I don't, it drives me crazy when they do that. All right, so we'll move on. I just wanted to make sure that we weren't missing something. Yes, what does that say? By holding this in, the Court of Appeal stripped patients of significant rights, divested therapists of their duties, and dictated to therapy. APA and CPA members have a vital interest in ensuring that if such termination is legally mandated, it be done under appropriate rules. So that's why they're writing this. All right, so statement of issues. Number one, whether the dangerous patient exception to the usual privilege protecting patient therapist communications is limited to the content of warnings given to third parties and the communications that triggered such warnings, or the exception voids confidentiality for the entire content of therapy. So if you remember, according to Dr. Oziel, who was the therapist that the Menendez brothers, or I guess Erik, confessed to, he made him bring Lyle in, and um, according to Oziel, Lyle threatened Dr. Oziel, threatened his life. So um, the brothers deny that that happened. Number two, whether the patient therapist relationship automatically terminates by operation of law whenever a patient threatens the therapist, or whenever either the therapist or the patient is no longer primarily motivated by a desire to engage in therapy. So, and that's another thing too, is that Erik stopped seeing Oziel. Erik was seeing Oziel when his parents were alive. They were the ones, Jose set it up and made an arrangement with Dr. Oziel that everything that Erik told Oziel, he was to tell in return back to Jose. So Jose could keep tabs on what Erik was telling him. And he agreed to do this, which already tells you right there what an unethical SOB he is, to say, oh, yeah, I'll tell you everything your minor son tells me in therapy. So there's that. But then he took after the supposed threat, the brothers came back and did a recording of their almost a confession kind of, but really just them talking through the situation and how things happened. And Oziel did a lot of talking on his own and putting a lot of his own speculative thoughts and speculative narrative within the conversation. And should any of that have should any of that have come into the trial is basically the question, because um, there were so many unethical things about Oziel to begin with that I don't think it should have come in, but also this case and the confidentiality that the APA and the CPA are trying to argue here. All right, so the statement of facts. On August 20th, 1989, Jose and Mary Louise Menendez were emmed in their home. Can't say certain words on YouTube, sorry. We just use short term or shortened whatevers. All right, so in March 1990, petitioners Erik Galen Menendez and Joseph Lyle Menendez, or the Menendez brothers, were arrested and charged. See, I mean, they both are together, so why would you um, think about reviewing their cases for release separately, as the new DA is doing. All right, so anyways, they were arrested and charged with the homicides of their parents. For some time after the homicides and before they were arrested, petitioners were treated in therapy by a psychologist, Dr. Jerome Oziel. Redacted factual findings. During a therapy session on October 31st, 1989, petitioners allegedly threatened the life of Dr. Oziel. That's according to Oziel. As the result of this threat, Dr. Oziel concluded that his family and loved ones were in danger. Later that day, he warned his wife, Dr. Laurel Oziel, and his girlfriend, quote unquote girlfriend, Ms. Judalon Smith. Dr. Oziel apparently relayed additional warnings to his wife in the next few days. He also sent them to go live in a hotel, and he went to go live with Judalon, or forced himself into Judalon's space, I should say. After the October 31st session, Dr. Oziel made a number of audio tapes relating to his treatment of petitioners. One tape contains Dr. Oziel's notes from his October 31st and November 2nd, 1989 sessions with petitioners. A second tape contains Dr. Oziel's notes from his November 28th, 1989 session with petitioner Erik Menendez. So just Erik, not both of them. A third tape is an actual recording of the therapy session between Dr. Oziel and petitioners held on December 11th, 1989. At all times during the 4 sessions at issue, petitioners intended and expected that their communications with Dr. Oziel would be kept confidential, as communications made in the course of therapy usually they are. On March 9th, 1990, police seized from Dr. Oziel the 3 audio tapes mentioned above, along with other documents. The prosecution seeks the right to introduce those tapes, all transcripts of their contents, into evidence at petitioner's pending homicide trial. When was this written? I don't know. Dr. Oziel and petitioners seek to exclude these tapes from evidence on the grounds that they constitute or contain privileged patient-therapist communications. After conducting in-camera hearings on the issue, the Superior Court ruled that all the referenced communications were intended by the brothers to be confidential within the meaning of the psychotherapist patient privilege, but that they lost their confidential status because Dr. Oziel reasonably concluded the disclosure was necessary to warn third parties of a danger posed by the Menendez brothers. But as we know, Judalon Smith said that he did not seem afraid of them. He seemed to view them more as a money-making opportunity and not really a threat. Subsequently, after various rulings by the Court of Appeal and this court, the Menendez brothers petitioned the Court of Appeal for a writ of mandate. The Court of Appeal acknowledged that the tapes contain confidential communications as defined in the California Evidence Code. It further acknowledged that such confidential communications fall within the psychotherapist patient privilege codified in the Evidence Code, and that the holders of the privilege, the Menendez brothers, could prohibit the disclosure of these communications some absent some exception to the privilege. The Court of Appeal held, however, that since certain statements made during the October 31st and November 2nd sessions between Dr. Oziel and the Menendez brothers prompted Dr. Oziel's warnings to his wife and Ms. Smith, everything said during those sessions fell under the dangerous patient exception to the general privilege rules and were therefore not privileged. The Court of Appeal also held that the tapes relating to the November 28th and December 11th sessions were not privileged because it said, as a sort of quasi-factual finding, those sessions were not held for the purpose of therapy. I'm sorry, what? How, what? How do they know what the session purpose was? That's a bizarre take. That's really a bizarre take to me. Hold on, I need a sip of water. Excuse me. All right. So the Court of Appeal seemingly based this holding on its conclusion that the therapeutic relationship between the Menendez brothers and Dr. Oziel must, as a matter of law, have disintegrated once petitioners threatened Dr. Oziel's life. But again, that's like his word against his word. It's just he said, he said. You don't really know. Oziel could be totally making it up. Court of Appeal also based its holding on its inference that following petitioners' threats, neither Dr. Oziel nor the petitioners were primarily motivated by a desire to give or receive therapy. Following the Court of Appeal's decision, petitioners were granted review by this court. Here's the argument. Summary of fact. The facts of record in this case do not paint a very appealing picture either of the petitioners or of Dr. Oziel. The Menendez brothers are charged with a heinous crime. It is not surprising that a court might incline towards admissibility of potentially highly probative evidence. The record indicates that Dr. Oziel had an extramarital relationship with Ms. Smith and employed her to eavesdrop on therapy sessions. So he hired her, whether he, paid her or not, but he asked her to listen in and be there in the lobby, in the waiting area to listen in on the sessions. Reportedly, Dr. Oziel's psychology licensure is now on probationary status. Well, when this was written at that time, he no longer has his license and he is not practicing. But I think he's doing. Oh, I can't remember what he's doing. I'll have to look him up. The Court of Appeals ruling is in. We did a session on that, or a stream on that, like where are they now? And I can't remember because that was before my surgery and I feel like I've lost all information in my head. So bear with me as I get back to it. The Court of Appeals ruling in this case rests upon two conclusions. One, that therapy by definition always terminates when the patient communicates a serious threat against his or her therapist. And two, that whenever a patient threatens a therapist, all post threat communications with the therapist lose their confidentiality. If this court affirms these conclusions, the chilling effect on potentially dangerous patients and their therapists will be so strong that few, if any, such patients will continue treatment following their voicing a threat. Therapists will be professionally obligated to inform these patients that confidentiality has ceased, and most such patients will leave. Therapy that could avoid future violence will not be provided, and future warnings will not be given. So that is a problem because you're not mitigating the situation at the time that it's happening. By abruptly aborting therapy to these dangerous patients, such a rule would result in more, not less, danger to the patient themselves, to therapists, and to the public. Equally important, public awareness of the rule would deter from ever entering treatment large numbers of people who are not sure that what they may say in therapy or how the rules may be applied legally. Finally, the Court of Appeal opinion substitutes for the relatively clear rule under existing decisions a vague rule that requires a court to reconstruct and divine the primary intentions of mentally ill people and their therapists. In People versus Wharton, this court struck a delicate balance between the compelling state interest in protecting citizens from harm and the constitutional, statutory, and common law rights of privacy in the patient therapy relationship. The Wharton decision held that only the content of actual warnings to third parties and the statements that triggered those warnings are non privileged under the dangerous patient exception. So that's actually the opposite of what happened here. So instead of making all future communications not non-privileged. It's just the only communications that are not privileged are the threats themselves. So even future communication outside or beyond that or after that warning or after that threat, um, anything that they say to their therapists after that would still be considered will be considered privileged. I don't know why that was so hard for me to get out. All right, so the Wharton decision held that only the content of actual warnings to third parties and the statements that triggered those warnings are non privileged under the Dangerous Patient Act or exception. The Wharton decision was decided by a 4-3 vote, with at least two justices believing that even this waiver of confidentiality went too far and construed the dangerous patient exception too broadly. But at least the Wharton rule embodied a balanced, common sense standard: confidentiality is breached only to the extent necessary to protect the public. So there really wasn't a threat anymore, potentially, I mean, you could say potentially there was, either way, but regarding Erik and Lyle, but I don't think that there was really ever a threat to the public or to Oziel. Now, however, spurred perhaps by the lurid facts in this case, the real party in interest seeks to sweep aside the Wharton rule in favor of a total disregard for confidentiality any time that a patient threatens the therapist. Because of the large number of patients who threaten a therapist or another person at some time, this would end confidentiality and perhaps therapy itself in large numbers of cases. This court should reject the invitation to so radically move beyond Wharton to discard confidentiality and to and to create a rule that will increase rather than decrease the public's exposure to dangerous people. The Court of Appeal construed too broadly the dangerous patient exception to the general confidentiality of psychotherapist patient communications. Exceptions to the evidentiary privilege protecting psychotherapist patient communication should be construed narrowly. California Evidence Code 1014 provides in relevant part that a patient, whether or not a party, has a privilege to refuse to disclose and to prevent another from disclosing a confidential communication between patient and psychotherapist. The code defines such a confidential communication as information transmitted between a patient and his psychotherapist in the course of the relationship and in confidence by a means which, so far as the patient is aware, discloses the information to not third persons. So, meaning if I go in there as Erik, thinking I'm going into therapy with my therapist and start talking about the crimes I did, I don't feel like I believe that those communications should be confidential, and I don't think that Dr. Oziel running to authorities would every time that I make some kind of comment about not liking something or whatever, um, or being displeased with something, if Oziel is going to run to the police and say, "Well, that was a threat to me," like when is enough enough? Where's the line that we draw? Of course, there are exceptions to this broad privilege, but the history of these code provisions, as well as subsequent case law, show clearly that the privilege was intended to be applied broadly and that any exceptions were intended to be applied narrowly. For example, the comment of the Senate Law Revision Commission to 1014 emphasizes that the psychotherapist patient privilege provides much broader protection than the physician patient privilege. So they have more protected communications with a psychotherapist. The Commission stressed that unless a patient is assured that intimate and embarrassing details will be held in utmost confidence, he will be reluctant to make the full disclosure upon which diagnosis and treatment depends. The Commission acknowledged that the granting of the privilege may operate in particular cases to withhold relevant information, but concluded on balance that the interests of society will be better served if therapists are able to assure patients that this confidence will be protected. Consistent with this legislative intent, California courts have consistently respected the breadth of the psychotherapist patient privilege. For example, in Skull versus Superior Court, the court refused to compel a psychotherapist who was accused of molesting a patient to release a list of his other female patients. So he refused to release a list of other female patients after he was caught essaying a female patient. The court stated that 1014 affords a broad privilege to prevent disclosure of confidential information, and that this privilege is founded upon the notion that certain forms of antisocial behavior may be prevented by encouraging those in need of treatment for emotional problems to secure the services of a psychotherapist. This court has itself acknowledged the need for near absolute confidentiality in treatment, as well as the benefit of society of encouraging potentially dangerous persons to seek treatment. In addition to being founded in the statutes, patient therapist confidentiality is a constitutionally protected privacy interest that can only be overridden by a compelling state interest. Because of the social and legal importance of this patient therapist privilege, courts have consistently held that exceptions to the privilege apply only in narrowly circumscribed situations where the government seeks to promote a compelling interest and where there is no less intrusive means of accomplishing its purpose. Mm, I start off there. I'm lost. Okay. Where does the sentence begin? Even when the patient voluntarily sues, there is not a complete waiver of privilege. Why is it just starts like that, the sentence? Oh, see, also in this other case, Lifschutz. And that's what I was confused about. Okay, so see also in this other case, Lifschutz. Even when the patient voluntarily sues, there is not a complete waiver of privilege. Rather, the patient litigant exception allows only a limited inquiry into the confidences directly relevant to the matters the patient has voluntarily disclosed and tendered in his pleadings. Court must balance a compelling need for discovery against the fundamental right for privacy. And even where the balance tips in favor of disclosure, constitutional concerns require a strict circumspection of the scope of the disclosure. The psychotherapist patient privilege has been broadly construed in favor of the patient. Thus, even where the legislature has identified a compelling state interest that justifies an exception to the general privilege, the courts must shape the exception so that it is intrusive on confidentiality as little as possible. Wharton properly limited the dangerous patient exception to the therapist's actual warnings to third parties and statements that triggered such warnings. California Evidence Code 1024 provides that there is no privilege under this article if the psychotherapist has reasonable cause to believe that the patient is in such mental or emotional condition as to be dangerous to himself or to the person or property of another, and that disclosure of the communication is necessary to prevent the threatened danger. This dangerous patient exception to the privilege has been applied narrowly by the courts. In Wharton, this court recently acknowledged that the exception should be applied only when the patient's case falls squarely within its ambit. Moreover, Wharton restated the well settled rule that constitutional concerns require a strict circumscription of the scope of disclosure. In Wharton, the lower court required a defendant's therapist to testify to the content. So this defendant committed M, and he was to testify to the content of certain statements made by the defendant during therapy. This court reiterated that under Evidence Code 1024, there was no privilege for those statements which were communicated to a third party pursuant to Tarasov versus Regents of University of California. The court also ruled that there was no privilege as to the statements made in therapy that triggered the Tarasov warnings. That holding sought to vindicate the legislature's intent by striking a careful balance between the need for confidentiality in the psychotherapeutic relationship on the one hand and the public safety concerns on the other. Under Tarasov, when a patient communicates to his or her therapist a serious threat to a readily identifiable individual, the therapist has a duty to take reasonable steps to protect that individual. Often such duty will be fulfilled, as in Wharton, by warning the individual target of the threat. That's interesting, huh? The court struck that balance explicitly by affirming that the privilege continued to apply to statements that did not trigger the warning. The court found that limiting disclosure to triggering remarks circumscribes the scope of the exception and thus acts in accordance with both the intent of the legislature and this court's prior pronouncements on the subject. This limitation on the scope of 1024 was crucial to this court's holding in Wharton. And another footnote here. Justices Browsard and Kennard dissented in Wharton, believing that the language and purpose of 1024 indicated that the waiver of confidentiality should be limited to only the content of the warning itself and should not go so far as to include prior triggering statements. Whether or not Wharton went too far, the Court of Appeal ruling in this case surely goes miles beyond Wharton. It is also consistent with this court's original ruling that Tarasov, even when disclosure of confidences is required, it must be done discreetly and in a fashion that would preserve the privacy of the patient to the fullest extent compatible with the prevention of the threatened danger. The Court of Appeal decision in this case would destroy Wharton's carefully balanced rule and expand 1024 far beyond its intent. The Court of Appeal ruled that Dr. Oziel had reasonable cause to believe that petitioners posed a danger to him, his wife, and his paramour, and that Dr. Oziel needed to do more than issue a vague warning. He needed to provide his wife and Ms. Smith with some reasons in order to convince them that the threat was real. However, the Court of Appeal provides no rationale for concluding that as a result of Dr. Oziel's Tarasov warnings, 2 entire therapy sessions should become non-privileged. So 2 entire sessions that followed the threat then were non-privileged, according to the court and the Court of Appeal. So Judge Stanley Weisberg, in the Menendez brothers case, both in 93 and 96, he said that um, these recorded sessions could come in. Portions of them were played, or maybe they were played in total. I can't remember. But yeah, so we listened to a lot of the recordings. Um, I don't remember what I was going to say after that. Sorry. All right. So the two entire therapy sessions became non privileged. The Court of Appeal leaped from deciding that bare warnings were inadequate in this case to deciding that two entire sessions which preceded the warnings were non privileged. It bypassed or ignored the balancing required by Wharton. The Court of Appeal decision is inconsistent with the constitutional right to privacy, the legislative intent of 1024, and the previous holdings of this court. This court stated in Wharton that limiting the waiver of confidentiality to the warnings themselves and the statements that triggered them was consistent with legislative intent and previous holdings because such a rule judiciously circumscribes the scope of the exception to the patient therapist privilege. Such circumscription, or indeed any line drawing, is missing from the Court of Appeal ruling. The Court of Appeal ruling is both unreasonable and unworkable. It is unreasonable because it would destroy confidentiality even as to patient therapist communications that have nothing to do with the subject of the threats or warnings. It is unworkable because it fails, unlike Wharton, to provide any pragmatic way of distinguishing what is privileged from what is not. Consider, for example, a patient who agrees to undergo therapy because of depression over job related stress. Assume, further, that during the course of the therapy sessions, the patient also discusses his marital problems and financial troubles. After several months, the patient communicates to his therapist a threat against the patient's supervisor, who he feels is pushing me too hard, and that the therapist warns the supervisor. Finally, assume that the patient later becomes involved in a divorce. Under the Court of Appeal ruling, confidentiality is destroyed not only for the patient's statements in therapy about his supervisor, but for everything he has said in prior sessions. The therapist presumably can testify in the divorce action about what the patient said about his wife, can testify in a creditor suit about what the patient said about his unpaid bills, and so on. Do you see how this totally unravels their ruling if you were to do this? It's a snowball effect. This is a truly bad rule of law. I'm going to highlight that because I like that line. This is a truly bad rule of law, meaning you guys, you done messed up. In therapy sessions, patients do not usually discuss a neatly organized sequence of subjects. They jumble together a lot of concerns. The Court of Appeal ruling means that if a patient discusses not only subject A, the threat to harm someone, but also subject Z, which is totally irrelevant to subject A, confidentiality is lost as to subject Z as well as subject A. This is not a speculative inference about the Court of Appeal ruling. The Court of Appeal itself cited the Superior Court's finding that each session was related to and inextricably intertwined with the one that preceded and followed it. On this theory, virtually everything said in therapy is intertwined with the subject of later testimony. So, I mean, it makes sense. If you're going to say, hey, once that threat happens, then nothing after that is confidential, that why would I continue going to see that therapist then? It wouldn't make any sense. And then your relationship with your therapist is completely lost. And you have to start over with a new therapist, I guess, if that were to happen. So the Court of Appeals ruling gives little guidance for determining what nexus, if any, between statements made in previous sessions and the threat made in a later session is necessary to justify the disclosure of the content of the prior therapy sessions. So again, how do we relate? How do we go about doing that? And deciding what is confidential and what's not? Where do we draw the line? The Court of Appeals seems to accept the ruling of the Superior Court in this case that all sessions are a seamless part of a single whole, and that 1024 therefore authorizes the disclosure of all communications made during any session for a patient who at any time voices a threat. So it therefore authorizes the disclosure of all communications. So basically, all confidentiality is lost. Many patients continue in therapy for years. This would mean that if a threat was made in 91, sessions from 87 might no longer be privileged if they were intertwined in the seamless web of therapy. This is hardly the narrow exception intended by the legislature. Such a rule also violates the constitutional right to privacy. It contravenes the well settled rule that a statutory exception to such an established privilege is constitutional only when it is narrowly limited to disclosure of directly relevant information. And I'm going to stop here and we'll begin where I just highlighted because we're about 15 minutes in and we're about halfway through the document. So, to spare you guys from having to sit through this whole thing and to give my body a rest, I'm going to stop it here. So, thank you guys so much for reading along with me. Um, this is a lot of this is like legal mumbo jumbo, but I hope you guys are getting the point that, this is allowing, if we allow all these conversations in once a threat is made, then where's the line? Where do you draw the line? Does every statement come in? Do previous statements come in? Because maybe it related to the same case. Or, if a guy threatens his boss and he's been complaining about his boss for years, do all those communications come in and it's no longer privileged? I mean, everybody can have a bad day and say something like, "Hey, I really hate my boss. I wish, he would die," or whatever. But that doesn't make it, that doesn't mean that it has a serious threat or tone behind it. It could be misconstrued for something worse, and they might feel obligated to say something. That doesn't mean that, years of complaints about this person have to come in to discovery in a trial. It just doesn't make that much sense to me, especially when we have patient therapist privilege. And I never understood why the tapes came in, but I get it because, how do you prevent them? Because they're supposed confession. So it's what the state has. It was basically their only evidence against them. So I don't know. We will continue next uh next week. Yeah, so this will be airing Thursday, and so next Tuesday, which I think isn't that New Year's. Uh-oh, I'm gonna lose battery soon. I better hurry up. Yeah. So next Tuesday, which is today's Christmas Eve as I record this. So Merry Christmas, Happy Holidays to all of you. And I will have the second portion of this for you guys out for you on New Year's Eve, as I was saying. So have a very Merry Christmas, Happy Hanukkah, Happy Kwanzaa, whatever you might celebrate, and enjoy. Spend time with your family and loved ones. And I will see you guys next week. Take care and have a good one. Bye now.